Eastern on C-SPAN 2. You can also watch online at cspan.org or with the new C-SPAN Now video app. Sunday on In Depth, a live conversation with author and New York Times columnist Ross Dalvin on
We also have waters back there. If anybody needs to grab the water, I know they were a little late.
Shh.
Still got a couple minutes before we get started, but
We can start.
do you want to go ahead and start?
Let's roll.
Okay, y'all ready? So awesome. So for those of you who do not know me, my name is JC Dubois, and I am the president of Texas Tech's Federalist Society chapter, which is hosting today's debate. And I want to start off by saying thank you so much for everyone being here. This is a great turnout. We're excited to have Professor Rosen and Professor Blackman speak on the constitutionality of the Texas Heartbeat Act and the Sanctuary City for the Unborn Ordinance. So I want to start off too by introducing our guests. So Josh Blackman is a national thought leader on constitutional law in the United States Supreme Court. Josh's work was quoted during 2 presidential impeachment trials. He has testified before Congress and advises federal and state lawmakers. Josh regularly appears on TV, including NBC, CBS, ABC, Fox, and the BBC. Josh is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and leading national publications. Since 2012, Josh has served as a professor at the South Texas College of Law in Houston. Josh is also an adjunct scholar at the Cato Institute. Josh has authored 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon. Josh has written more than 6 law review articles that have been cited nearly 1,000 times. He was selected by the Forbes magazine for the 30 Under 30 in Law and Policy. Now moving to our very own Professor Richard Rosen. So Professor Rosen joined the TTU faculty after completing a distinguished career as an officer in the Judge Advocate General's Corps in the U.S. Army. He was a litigator for a Miami law firm for several years before joining the Army as a judge advocate. Before retiring from the military, Professor Rosen was commandant of the Judge Advocate General School, the U.S. Army, in Charlottesville, Virginia, where he commanded the Army's ABA-recognized law school. He also spent time as the Chief of Personnel, Plans and Training at the Pentagon in Washington, D.C., and served as special counsel to the Assistant Attorney General for the Civil Division in the Department of Justice. Professor Rosen is a Glenn D. West Endowed Professor of Law and Director of the Center of Military Law and Policy. Both of these gentlemen have been interviewed and written numerous commentaries regarding the Sanctuary City for the Unborn Ordinance and the Texas Heartbeat Act. Please join me in giving them a round of applause. We're going to begin this debate where Professor Blackman is going to make his opening argument, and he will have 15 minutes.
Thank you. You guys have good timing here. JC and I booked this event nearly 2 months ago. We had no idea that November 1st of 2021 would be the day the Supreme Court heard arguments in the SBA case. I just spent the last 3 hours listening. They finished 3 minutes ago. Seriously, they finished 3 minutes ago, 3 hours. So I am the first human being to actually probably speak about this case in any sort of forum. So God bless West Texas. We're here, and we can make this work. So a brief overview of Supreme Court case law. As I'm sure you all know, Roe v. Wade, 1973, held that there was a constitutional right to abortion. And that decision decided there's a trimester framework. If you're in the first trimester, the state really can't do much. If you're in the second trimester, they can regulate a little bit more, but not very much. By the third trimester, the state has far more latitude to prohibit abortions. Fast forward about 2 decades, we get to Planned Parenthood versus Casey. In Casey, the court does not overrule Roe. They also don't affirm it in its entirety. They affirm the so-called core holding of Roe. They say, trimester framework, we're going to get rid of that. Instead, we'll draw the line at viability. Prior to the point of viability, the state cannot impose an undue burden on abortion. That's a test, undue burden. After the point of viability, the state can impose regulations. Now, of course, the point of viability is not fixed. It changes based on neonatal technology and other things. The court didn't really address that point. They said, we'll deal with it later. More recently, we have a case called Whole Women's Health versus Hellerstedt from 2017. Texas enacted restrictions on abortion clinics. They could not have, doctors had to have admitting privileges to nearby hospitals, that the clinics had to have surgical standards. The Supreme Court said in a 5-3 decision, those are unconstitutional, and the court followed the Casey framework. That brings us to the present. Last summer, Texas enacts SB 8. Around the same time, Lubbock, your city, enacts the fetal heartbeat law. These laws regulate abortions at roughly the 6-week mark when cardiac activity is detected. But these laws are unique in that they don't permit the executive branch to enforce SB 8 or the Lubbock law. They're basically the same thing. I'll just say SB 8 to make it easier. Instead, private litigants are responsible for enforcing the law. That is, a person can go to a court, file a complaint, and say, so-and-so performed an abortion after 6 weeks, I am suing the doctor. Or perhaps you can say, so-and-so funded an abortion after 6 weeks, I am going to sue that person. Or an insurance company. The range of potential defendants is quite broad. It's not just the doctor, it's the clinic and people who support them. But even broader than the range of possible defendants is the range of possible plaintiffs. Each and every one of you are a potential plaintiff under SB 8. Any one of you could be a plaintiff, okay? This law went into effect on September 1st. Before that date, various abortion clinics, Whole Women's Health, Planned Parenthood, and others filed a lawsuit in federal court in Austin. And they sought a pre-enforcement challenge as they want to stop the law from going into effect. These are fairly common. But SB 8 was designed with the express intent to frustrate pre-enforcement review. It was designed for that reason, and anyone who wrote the law will be candid enough to admit that. Go ahead.
Go, keep going. I'm just fixing some
You can
sound.
stop if you tried. And I might go a little beyond 15 minutes because I need you to sort of lay the foundation.
That's perfectly
That's fine. SB 8 was designed to frustrate this type of pre-enforcement review. Why? We often think of courts striking down laws, right? But that's a myth. Courts do not strike down laws. They issue injunctions. They enjoin particular defendants from enforcing particular laws. As a practical matter, it doesn't matter. If you enjoin the Attorney General from enforcing a law, the law has no effect because only the AG can enforce it, right? But SB 8 says the AG cannot enforce it. This creates what I call a game of whack-a-mole. Remember the game of whack-a-mole at the carnival, right? We hit one mole, another one pops up, hit that one, another pops up, right? They keep popping up, you never get them down. SB 8 works in the same fashion. Let's say John Doe sues an abortion clinic for performing an abortion, right? A court could hold, okay, this abortion was constitutional. Then Jane Doe sues the same clinic for the same abortion. And the court says, okay, get the picture ready, this is constitutional. And then Jane Roe sues the same clinic a third time, right? This sort of death by 1,000 cuts creates a chilling effect. Even though the clinics probably know that at some point a court will rule that you can't impose liability, the threat of liability is enough to chill performing of abortions. And indeed, we've seen this in Texas with post-viability abortions post-6-week abortions have dropped to more or less zero in the state of Texas. Now, a district court in Austin granted a pre-enforcement challenge to SB 8. The Fifth Circuit put that on hold. And then the plaintiffs took an emergency appeal to the Supreme Court. And by a 5-4 vote, the court said, we will not grant relief. And the court said, this is very novel, right? Why was it novel? The plaintiffs sued not just the Attorney General, but judges. The plaintiffs sued every judge in the state of Texas. Well, not exactly. As the case initially arose, they sued one judge and they sought to certify a class. They never quite got that far. So the case actually only involved one judge. They also sued every clerk in the state of Texas, clerk of court, but not exactly. They failed to certify a class. So as the case came to the Supreme Court, there was one defendant who was a judge and one defendant who was a clerk. That's really about it. So even if Planned Parenthood got all the relief they wanted from the Supreme Court, it would have only affected that single thing. Hey, you can come to watch YouTube. Hey.
Watch YouTube?
Yeah, just go to my YouTube channel. It's there. Sorry.
Okay.
Yeah, just Josh and Black on YouTube. It's there. It's live.
Okay.
All right. Anyway, much simpler with futzing.
Oh, yeah. No,
Yeah.
this is good.
Okay.
Continue.
So I will continue. Thank you. So it goes to the Supreme Court, 5-4 vote. The court says we cannot grant any relief. Right? We cannot grant any relief because this is very novel. Case goes back down to the lower court. A few days later, the United States Department of Justice files a suit. DOJ says, we are representing all the women in Texas who cannot procure abortions. We want to challenge this nullification of constitutional rights. Once again, the district court granted an injunction, goes to the Fifth Circuit. Fifth Circuit says, no, United States, you can't do this. What's your interest in this case? And then DOJ files an emergency appeal to the Supreme Court. Okay? DOJ files an emergency appeal to the Supreme Court. Thank you.
Yeah.
DOJ files an emergency appeal to the Supreme Court. The Supreme Court moves rocket fast, what I call the rocket docket. In the span of 10 days, they put the case on schedule for oral argument. The Supreme Court doesn't usually move this fast, but they move this fast now. Okay? They scheduled arguments for today, this morning, 3 hours ago. So at 10 Eastern, 9 Central, they heard 3 hours of arguments. 3 hours, right? The first 90 minutes concerned the case brought by the private clinics, Whole Women's Health and others. The second 90 minutes concerned the case brought by the United States against the state of Texas. By the way, when I say Texas, all of you are defendants. You didn't know this, right? You are now a defendant in federal litigation because you are a possible person who could sue under SB 8. So you've all been sued. You weren't served, which is kind of a problem, but you were all sued. Okay. So now let's actually get to the heart of the matter. Usually when we talk about a Supreme Court case, we say, what is the governing precedent, right? What precedents guide this case? The arguments today actually had nothing to do with Roe. So that title might be a little bit wrong, right? The arguments had nothing to do with Roe and nothing to do with Casey. I'll maybe talk about those cases later, but now I want to talk about a case that you maybe heard of or maybe wish you never heard of, which is Ex parte Young. Who here's heard of Ex parte Young? You've taken Fed courts? Okay, yeah, not enough of you. All right. So we have something called the 11th Amendment, right, to the Constitution. The 11th Amendment, broadly speaking, says private citizens cannot sue the state. Can't sue the state because of what's called sovereign immunity, right? Now, Congress can make an exception to that. Congress can say, well, if you're violating civil rights, you can sue the state officials. So that's what's called Section 1983. You've heard of Section 1983? Yes. Section 1983 is an exception to the usual rule of sovereign immunity. So if, let's say, a police officer violates your Fourth Amendment right, you can sue for damages in certain cases. Okay. But SB 8 doesn't involve suing for damages in this regard for a certain violation of constitutional rights. Instead, they're seeking injunctive relief to stop the enforcement of SB 8. So there's a case that says, a case called Ex parte Young from early 20th century. And this case says, if a executive branch official is violating your constitutional rights or is threatening to violate your rights, you can sue them. What's called a pre-enforcement challenge, right? You have to wait to be enforced. You can say, you threaten my rights, I'm taking you to court, and you can seek prospective injunctive relief. That's injunctive relief for the future. Ex parte Young is pretty well settled. It's been around for 100 years. Everyone knows it. If you ever take Fed courts, you'll read it pretty early in the semester, I think. But there's some language in Ex parte Young that says, well, the person you sue is the executive branch official. You don't sue the courts, right? To sue the courts would basically frustrate our entire system of government. So that was a problem, right? That SB 8 plaintiffs said, we want to sue the judges. We want to sue the clerks of the courts. Before this morning, I would have said, well, SB 8, sorry, too bad. Ex parte Young is the law. But unfortunately, Justice Kavanaugh decided, seems like he wants to make an exception to Ex parte Young. He says, well, I know the language is there, but the principle is broader. So I think, once again, to quote Justice O'Connor, abortion will be an ad hoc nullification machine where you have this law, you create carve-outs for abortion. So I think the court will probably say there's an exception for Ex parte Young to sue the clerks of the court, if not the judges themselves. But there's a problem here, right? If you enjoin the clerks of the court, what happens if the judge dockets the case himself? Uh-oh. Yeah, I think Gorsuch mentioned that. I got to get the transcript. I think it was Gorsuch. So I don't even know how that works, right? The justices say things, they don't always think them through, but this is potentially one way they might do it. They'll simply say, well, you can't sue the judges, but you can sue the clerks. And I suppose if you sue the clerks, that would, in large part, neuter SB 8. I need to go back to the transcript, right? So that's the first half of the case. The second half of the case is the United States. If the private plaintiffs win, if Whole Woman's Health wins, the court doesn't need to deal with the United States case, right? That they just won't deal with it at all. But let's say, Justice Kavanaugh decides not to rewrite Ex parte Young. What's the court going to do? I think they have to turn to another case in the late 19th century or late 20th century. No, late 1800s. It's called In re Debs. You may know the name Eugene Debs. He was a socialist, ran for president. He was involved in various speech prosecutions during World War I, but he was also a labor organizer. And he was one of the leaders of the Pullman labor strike, a very famous labor strike from the late 1800s, where a lot of the railroad employees were going on strike. Okay? In re Debs, the United States filed a suit against Debs, saying that Debs' strike was violating federal law. Now, this is a very weird case, because usually when there's a strike, it's a dispute between the workers and the employer, right? That's how strikes usually go, and usually they fight themselves out. But here, the United States stepped in and said, this strike on the railroads is frustrating interstate commerce, right? That because you're allowing these workers to go off the job, you're frustrating the free flow of commerce between the states. Therefore, the United States has an interest. This was always a weird case, my friends. It never really made a lot of sense. It's always been this kind of outlier in federal jurisprudence, and it hasn't come back since. So bring in the United States. The United States argues, under In re Debs, we can sue Texas because Texas is nullifying constitutional rights. This argument did not get a particularly warm reception at the Supreme Court. Even Roberts and others saying, wait a minute. You mean the United States can step in anytime rights are being violated? Just use an example. During the Civil Rights era, could the United States start suing states for having segregated schools? They never tried. Congress actually enacted laws which allow that, but the United States never tried to sue on their own in the absence of a statute. So I think the United States is probably going to lose here. I think the court's probably going to fail precisely because the United States has no interest in whether these rights are being violated. The United States might have a small interest. For example, let's say you have a federal prison in Texas and a prisoner needs an abortion. I think you could not impose liability on someone who helps the federal prisoner get an abortion. But that's a really narrow aspect of the law. Again, courts don't strike down laws. They can just enforce applications of it. SB 8 has a wicked severability clause. It's extremely intricate. So even if part of the law becomes invalid, the rest of it will remain in effect. This law was actually written in large part to Whole Woman's Health versus Hellerstedt, the case I mentioned earlier. Texas enacted this massive restriction of abortions, admitting privileges, surgical standards, but some of them are pretty benign. For example, abortion clinics must have smoke detectors. Does anyone think that requiring a smoke detector puts an undue burden on abortion? Of course not, right? It's a crazy argument. But Justice Breyer said, we're not going to go through and pick through. We're just going to kill the entire statute. The reason why we have SB 8, I think, is because of smoke detectors, right? Because Breyer was so, lazy and unwilling to actually engage the statute, we have this insane severability clause to try to avoid that remedy. All right, so to recap today, and I promise I'll get to Roe, I promise. To recap today, I think the court will rule in favor of the providers. Justice Kavanaugh was really bending over backwards, reading cases like Shelley v. Kramer to authorize a suit. I mean, he's on a mission. Got some bad PR last time, so I guess this will help him out. Justice Barrett was also kind of skeptical of SB 8. And there's one aspect that does go to Roe. SB 8 says you can raise certain defenses. And those defenses do not map on perfectly to Roe and Casey, right? For example, the law says you can raise a defense and raise the undue burden standard. What about the third parties, right? What if you sue an abortion clinic? It's not clear that they can raise the same defense. I think Gorsuch, maybe Alito, made this point in response. Who cares what the statute says? If a statute is unconstitutional, a judge can adjudicate it and decide you have more defenses to raise. So I didn't get Barrett's point. I think either she was maybe misreading the statute or maybe there's some other argument she didn't fully flesh out. But I don't think it really matters what defenses are in the statute. The statute was not written with the idea of making a perfect tool for abortion clinics to litigate. It was designed quite the opposite. But I don't think this really affects the case here or there. So I think the plaintiffs win in Holman's Health for Telus at 6-3, maybe even 7-2. Thomas seemed a little bit apprehensive. And Thomas said several times that the litigants are like private attorneys general who are involved with state action. So I think actually may have some litigation from just unpredictable response from Justice Thomas. But I think the Fifth Circuit gets stayed. Still, and this point's important, even if the clinics can sue, right, that doesn't stop SB 8 in its entirety, right? It isn't, just use an example, the courts have held that abortion clinics can raise a right to abortion. It's called third-party standing under Craig v. Boren. It's not clear that an insurance company has a right to fund abortions, right? It's not clear that a company has a right to provide donations to an abortion. There are lots of groups that support abortion that aren't actually performing them themselves. So even if the court says, yes, you can sue, that doesn't end the law. And these clinics still face significant consequences and harm. So I think that, the justice may think, oh, we'll just wash our hands of this case. It ain't over, my friends. Okay, that's the first half. The second half, I think the United States loses. This was a risky suit for the Biden administration. It really was. They wanted to bring the suit. At one point, I think it was Justice Alito or Gorsuch asked, would you have brought the suit if California regulated firearms? And she said, of course we would. I actually started laughing out loud. Like, no, you wouldn't. Right? This is abortion. Right? There's a very famous quote from Justice O'Connor from the 1980s. She said, no legal rule or doctrine is safe from ad hoc nullification by this court when an occasion for its application arises in a case involving state regulation of abortion. No rule safe. So for whatever reason, when abortion's involved, old rules got the window. Let's revise ex parte Young after 130 years. What the hell? And that's what they're probably going to do. All right. So now let's actually get to the question presented that JC was kind of to invite me for over the summer. What's with Roe? Right? What's going to happen? 1 month from today, December 2nd or 1st, 1 month from today, the case will be heard. Dobbs versus Mississippi. Texas regulated abortion at roughly 6 weeks. Mississippi at 15 weeks. Okay? 15 weeks by any measure of science is before the point of viability, right? No matter who you ask, 15 weeks is early. Some people say 22, 23, 24, depending who you ask, you get different answers. But 15 weeks is before viability. Dobbs squarely presents the challenge to overrule Roe, right? It's a straight up challenge. There's no sort of dancing around it. The plaintiffs in that case, the defendants in that case are asking the court to overrule Roe v. Wade and Casey as well. What's going to happen here? Oh man, again, when a case involves abortion, no legal rule of doctrine is safe. They seem to just find ways to save abortion cases in every single instance. If you'd asked me yesterday, I say there's a good 50% chance the court overrules Roe. Today, I don't think after this it's going to happen. A couple times, the justices, Barrett and Kavanaugh, sort of suggested that this is something that's bad, and I just got the vibe that they're not sort of down for the cause, so to speak, right? They don't see this case the same way that that Alito, Thomas, and Gorsuch do. I think they are apprehensive about moving too quickly. I think they're worried about the so-called legitimacy of the court, institutionalism. This word legitimacy is like kryptonite for judges, just sort of makes them weak. I think they really worry about this, and they want to move slowly and incrementally. And so now their first or second term on the court, they're not prepared to go that far. I am, I'm just very skeptical. I thought there was a chance the court could go through it. Now, what happens next, right? Assuming you are not prepared to overrule Roe, is there something short of that? It's possible. The court can say, well, we're not getting rid of the right to abortion. We're just going to rewrite the standard. Right? We're going to rewrite the standard. We're going to say, well, undue burden means something different, right? We're going to reinterpret the undue burden standard. So, for example, the court could say, we think 6 weeks is too much, but 15 weeks is okay, Goldilocks. But then the question is why, right? How do judges go about crafting different standards, different grades for abortion? Roe v. Wade, for all of its flaws, had simplicity, right? The trimester framework is predictable. 3 months is 3 months, no matter who you are. 3 months is 3 months. By shifting to viability, there's a different standard, right? Because viability will inherently fluctuate based on the state-of-the-art technology. So if it's not trimester and it's not viability, then what is the standard, right? Because 15 weeks, again, is prior to viability. One standard that I've been kicking around, and I have no idea if this would actually even work, is when a woman knows or should know she's pregnant. This will get a little bit, perhaps, TMI, but it's true. Most women realize they're pregnant at some point, right? Some women never do. It's true. Some people who have irregular periods, otherwise, they just never know that they're pregnant. And sometimes they find out when they're in the delivery room. It happens. But most people know. And that can be when you have a missed period or you take a home pregnancy test, et cetera. I can see the court crafting a standard based on that fact, that if you know or should know you're pregnant, and some delta after that, at that point, it's too late. By the 15-week mark, I've looked into numbers on this. People know they're pregnant by a large number. There might be exceptions, of course, but they know they're pregnant. And if you choose to know you're pregnant after a certain period of time and don't choose to terminate it, then that right vanishes. I came up with this myself. I don't know if it's even a good policy or not, but I can see them trying. Because look, if you don't use trimesters and you don't use viability, you got to use something, right? You can't just say, well, 15 weeks good, 6 weeks bad, we don't really care why. Then some state will say, okay, we'll do 14 weeks, and we'll do 13 weeks, and we'll do 7 weeks, right? They'll keep just pushing the line and just create a never-ending stream of litigation. But still, even to do that, the court would have to reaffirm Roe v. Wade's principle that the Constitution protects the right to privacy, right? You need to reaffirm that there is this unenumerated substantive due process right to abortion, which is going to be hard, right? Chief Justice Roberts eviscerated substantive due process in the gay marriage case of Bergefell. He eviscerated it, right? Which is why I think at the end of the day, the path of least resistance is to do nothing and just reaffirm those cases and say, under Casey, this law is invalid, go home, Texas, right? Go home, Texas, adios. So I think especially after today, just listening to the tenor, and it's hard to listen to a case, but there's just subtle ticks and the way the justices are kind of on their edge and the way they inflect their voice on one side and not the other. You can see which way they're leaning. It's not perfect. It's not a science. It's not even an art. It's a little bit of criminology, scotusology, I call it, right? You're kind of just like looking at very subtle clues. But I listened to all 3 hours, and I just heard the way Roberts, Kavanaugh, and Barrett were just on edge. And the fact that they expedited this case so fast, there's no reason to decide this case in 10 days. None, right? They could have granted a stay and decide this in June, but to decide this in just such a rapidly fast period suggests that something's up. I think there was blowback from the last decision in September, but I don't know. All right, I've been going well beyond my 15 minutes, but I appreciate your attention. This has been a wonderful audience. Professor Rosen will speak for a few moments, and then I'll come up and we'll answer some questions, but I'm so happy to be here today. Thank you. You want to stand over there? The camera's over there. Oh, okay. Yes.
Okay, good afternoon. I want to say that I'm honored to be here with Professor Blackman. I follow his posts religiously on the Bollock conspiracy. and take a lot of my material from them, as well as reading his law review articles, which are quite eclectic in terms of con law, everything from the Emoluments Clause to the Second Amendment. And so I was asked to be here today to talk about whether SB 8 and the Lubbock Sanctuary City Law are unconstitutional. And after hearing the oral arguments today about SB 8, I'm not sure anymore. The Supreme Court and the Fifth Circuit, in fact, in the Dobbs case, which is going before the Supreme Court, has made it clear that states can't prohibit abortions before viability. They can impose some regulations, health regulations, informed consent, but they can't impose an undue burden on a woman's right to choose. The Lubbock Sanctuary City Ordinance, in fact, was considered by the district court here in Lubbock, U.S. District Court in Lubbock, and it dismissed the case because of a lack of standing. And we see now what's happening to SB 8. The Lubbock Sanctuary City Law actually prohibits all abortions. It says that Texas laws that criminalized abortion are still in effect, but for Roe versus Wade and Planned Parenthood versus Casey, and ban all abortions except for medical emergencies. Clearly, that is unconstitutional. It prohibits and provides civil remedies for abortions any abortions that occur in Lubbock. And it allows a couple of kinds of lawsuits. It allows the woman who gets the abortion or members of her family to sue for civil damages for performing the abortion. And it also has a statutory remedy for any Texas citizen to sue, and the damages there are $1,000. In this respect, the law isn't really unique. There was or is a Louisiana law that was considered by the Fifth Circuit back in 2001 called Okaloobi versus Foster, where a woman was allowed to sue abortion providers for an abortion she received. And understand that these lawsuits are allowed even if the woman gives full informed consent to the abortion. SB 8 is somewhat different because it has the cutoff at fetal heartbeat, which is 5 to 6 weeks, as opposed to 22 to 24 for viability. Clearly, to the extent that damages are allowed for having a constitutionally protected abortion, I would think is unconstitutional. How you get to the unconstitutionality is the other question. And we heard oral arguments about whether there can be preemptive challenges to the law brought by either abortion providers or by the United States. Ultimately, I would believe, or at least I did until I heard the oral arguments today, that if these cases are heard in state court, and we were assured by the Solicitor General of Texas that this is the case, that state courts would follow the federal law. So ultimately, the abortion providers or people who aid and abet abortion would win the case in state court. And maybe that's not completely true, as Professor Blackman pointed out, with respect to the undue burden provisions of SB 8. It doesn't cover people, for example, who finance abortions, insurance companies, for example. What surprised me today, because it doesn't appear like this in the statute, and they spend very little time in their briefs, is the argument made by the Solicitor General of Texas that that Roe versus Wade and Casey fully apply, and that lawsuits will essentially be dismissed if they challenge pre-viability abortions. I assume if someone brings a lawsuit then for a pre-viability abortion, not only will the case be dismissed, but it seems to me pretty frivolous. in which case, under Chapter 10 of the Texas Civil Practice and Remedies Code, costs can be imposed. I thought about this last night when I was reading the brief of Texas, the briefs that Texas provided. And it seems to me that their argument that lawsuits will not occur if they're prohibited, or they will be dismissed if they're prohibited by Roe and Casey, that's it's cute by half. It's disingenuous, because there's also a provision in SB 8 that these laws are retroactive in the event that the Supreme Court overturns Roe versus Wade in the Dobbs case. A lawsuit that's pending or a lawsuit that's filed after Roe and Casey are overturned will be allowed to proceed for abortions that occurred before they were overruled. So in other words, it has retroactive effects. So if abortion providers provide pre-viability abortions today that violate, for example, the Fetal Heartbeat Act after the 5th or 6th week, but before viability, they could be sued after the Supreme Court, if it does overrule Roe versus Wade. They could be sued for damages, even though the abortion that was provided was constitutionally protected. But I was surprised by the Solicitor General's argument. There's nothing in the statute that gives an exception for Roe versus Wade. In fact, the only exception is for medical emergencies. There is a provision that allows, to some extent, an undue burden defense, provided that there is third-party standing. But to bring it, to condition these lawsuits on Roe versus Wade and Casey really surprised me. I do want to make just a number of other observations. I noticed that the United States asserted that it cannot imagine a federal official being sued in these cases. Their complaint belies that assertion. For example, the United States' lawsuit specifically talks about the government's interest in having abortions provided by, for example, military doctors on military installations in the event of rape or incest, which is not accepted, incidentally, under SB 8. There is no exception for pregnancies because of rape or incest. They also talk about, in the complaint, other federal agencies who might contract with providers for abortions, for example, in federal prisons and others. Clearly, if a military doctor is sued for providing an abortion under this statute, that would provide instant federal jurisdiction. You remove under 28 U.S.C. Section 1442 or 1442A. I might also note that, as an aside, with respect to our major installations coming from the military, I have to note this, that state law or SB 8 doesn't apply to places like Fort Hood and because they are exclusive federal jurisdiction installations. So if you want to get an abortion and you want to be safe from a lawsuit, you do it on a military installation. With respect to contractors who provide abortions for the federal government, I think an argument can be made for the government contractor defense, and they'll be able to get the case into federal court under Section 1442. In any event, The bottom line is that to the extent that someone could be sued for providing a pre-viability abortion, I believe that the lawsuit should be dismissed by the state courts if the federal courts can't preemptively enjoin these laws. The state courts ought to dismiss them as violating the federal Constitution, something that the Texas Solicitor General assured the Supreme Court would be done. One final note, in an article I've written for our law review, which may be overcome by events, depending upon what the Supreme Court does, Texas judges are elected, and they're elected by political party, which I found to be quite odd when I became a Texas resident. I'm from Florida. We have a different method of selecting judges. I'm sure they look at their likelihood of being reelected if they decide contrary to what their constituents want. So, for example, in Lubbock, the Lubbock City Council essentially refused to pass unanimously the Sanctuary City for the Unborn ordinance. It only passed by popular initiative with 2/3 of the voters favoring the initiative. Judges I know in Lubbock probably won't be swayed by that, but who knows? And so one would hope that state court judges will step up to the plate and carry out their duties under the Constitution, under Article 6 of the Constitution, and dismiss these lawsuits. Thank you.
Thank you so much. I think we have more agreement than disagreement. And I think it's somewhat precarious even me talking about Supreme Court cases when they're deciding the case this week, right? So it's like we're in the zone of twilight, if you will, where things are sort of up and down, left and right, bright and dark. Let me make a few more points, though. I think we all can concede in candor that this Texas law was designed to try to make it harder to challenge in court. And that raises a question. Is there a constitutional right to is there a constitutional right to a pre-enforcement challenge? In other words, must the federal courts offer you a way to get to court before you're sued? I'm sure you have a lot of you say the tort of defamation, right? And maybe you read the case New York Times against Sullivan, right? This is a case where the New York Times published an advertisement that was critical of certain public officials in Alabama that concerned civil rights, and they made some statements that were false. And these public officials in Alabama sued the New York Times for a lot of money. Now, of course, maybe their reputations were harmed, but this was designed to chill the civil rights movement. I think we've all conceded that. And the court said, well, it's harder to sue when you're a public official, so they sort of watered down the defamation tort with this actual malice standard. But still, the court didn't say, well, you can go to court in advance and challenge the defamation statute on its face before you even get sued. So I think what this law is trying to do is exploit. I think Kavanaugh called a loophole several times. Kagan called it a chink in the armor. I'm surprised she used that expression. She might get canceled for it, right? But I think this was a law designed to exploit an opening. And the reason why this law was designed to exploit this opening was because of Roe and Casey. That it's been viewed that there's been this usurpation of state law for 5 decades. And it's almost like a countermeasure. Okay, if you're going to rewrite the Constitution, we're going to find a way around it consistent with the law. And I think once again, the court will find a way to stop it. All right, I will stop here and make sure there's plenty of time for questions, but thank you all so much. Okay, let's start on this side, then do this side, then do this side. Just make it easy. Okay, questions on this side. It's like my head doesn't turn all the way around. No. Okay, middle section. Nothing? Did nothing we say gin up any thoughts at all? Okay, yeah, in the back, go ahead.
In the introductory language to SB 8, they cite the fact that Texas never repealed its abortion statute.
Did not
And I'm wondering if they're gonna use that for a similar argument and standpoint in the future, because there's a number of laws Texas hasn't repealed that are constitutionally invalid now.
Oh, what a good question. Excellent question, brother. Thank you so much. Let me repeat something I said earlier. Courts do not strike down laws. They don't. They simply enjoin enforcement. Texas's abortion law, which was in effect for Roe, that's why Roe arose, was never repealed by the legislature. Roe v. Wade said you can't enforce the statute. It's unconstitutional. But Roe didn't erase the statute from the books. If Roe was overruled, then nothing prevents Texas from enforcing the 50-year-old law from the 1970s. Many states have criminal prohibitions on abortion. In fact, I think it was Massachusetts a couple of years ago actually repealed their abortion law. They've been in the books for half a century, never enforced, of course. And I think that your question, why I like it so much, is it illustrates a point. Courts issue judgments against people, not laws. A few times today, Sotomayor said, well, we can enforce the law, join the law. And that betrays a fundamental misunderstanding of how courts operate. So let me take a step back. Does anyone know the name Jonathan Mitchell? Do you know this name? He was the former Texas Solicitor General. He was my law professor. I've known him now for 15 years. He was one of the architects at SB 8. And he wrote an article called The Writ of Erasure Fallacy. And he's been trying to prove to everyone the courts cannot erase his laws. I think in some small part that this entire episode is a way to prove Mitchell was right. And that to stop Mitchell, the court's going to have to redefine its doctrine. Right? In other words, if the court changed its doctrine, then of course he was right then, but now he's wrong. The court can always make stuff up. But I think we're sort of living in Jonathan Mitchell's world. I knew this was coming. I saw this years ago, which is why I prepped him so ready for it. But for a lot of people, it's like, oh my God, let's enjoin the law. No. That's not how it works. So if nothing else, the court will have to grapple with how many courts have simply misunderstood their own authority. Okay, other questions? Yes, in the back.
Yeah, so Justice Kavanaugh asked a question, and he was asking the Texas Attorney General his thoughts about, if I guess it was if Texas thought through whether other states would be able to do something like this to allow people to chill, perhaps the Second Amendment, which, something that would maybe happen in California. And I don't really think that Texas gave a very good answer.
No. They gave a very good answer. The only answer is nothing would stop it.
So
yeah, that was the answer that they gave it.
Texas's intent with forming this law, because it seems to create policy, or I don't know, it kind of looks, it reveals what we all know the intent of SBA was, which is to.
Well, look. Let me give you a legal answer and a non-legal answer. Nothing would stop California from, prohibiting private gun ownership. Nothing would stop Massachusetts from prohibiting hate speech through these sort of private enforcement mechanisms. The reason why, and I'm being completely candid here, those laws wouldn't work is because DC v. Heller is not at risk of being overruled, right? First Amendment case law is not at risk of being overruled. I think if you told gun owners we're going to ban private ownership, they would say, come on, Texas, what would they say? Gonzalez? Come and take it. Thank you. God, at least one of you is here, right? They would say, come and take it, sue me, and I'll win, right? I really do. I mean, I've given this thought. I know there's an amicus brief that suggests otherwise, and I think that brief makes point they have to make. But I think truly, if this was enacted for hate speech and for gun ownership, it would never work because people would say, okay, come and sue me. The reason why this works is because Roe is in jeopardy, right? Or at least I think it might have been, right? The clinics know that if they perform an abortion today and in 6 months it overrules Roe, they are on the hook for massive liability, right? So they're anticipating that eventuality. Okay, but it's a good question. But I think Texas answered the question the only way they could answer, which is nothing would stop it. And that's the answer. I mean, it's not a bad answer. Often with you ask me advocates, right? Sometimes there's a policy question that you're going to have to just take and say, yep, but we went on the law, right? If you don't have the law, argue policy. On the policy, argue facts. And if you don't have the facts, pound the table, right? They had law. It's like, okay, we went on the law. Okay, other questions? Yes, right there.
Kind of going along with that, if other states kind of jump on this bandwagon, you think that this might have a chilling effect on the rule of law in general? That you just do some diligence to start enforcing statutes?
Say one more time. I think I missed the last part of your question.
I was saying if the SBA is somewhat successful in court, I know there's more about how other states, they might use this to, for example, try to enforce gun control or something. Do you think it's going to have a chilling effect on the rule of law in general? Do you think people start trying to find other loopholes, other places to get what they want for this thing?
Yeah, so the question was, well, if you couldn't hear it, is will this regime, this SBA regime, have an effect on the rule of law more broadly? I'm going to answer your question the way you may not like. I think Roe for the last 50 years had an effect on the rule of law. I think Roe's removed a question from the political process that should be there. So yeah, but I think Roe is, I mean, again, I don't think you can detach the fact that California never tried to ban gun ownership after Heller. Right? No one thought to do that. Right? No one thought to ban hate speech after First Amendment cases like Snyder versus Phelps. No one thought to do that. This only arose precisely because of the 50 years of Roe. In particular, I keep coming back to smoke detectors. Holman's Health versus Heller said that opinion was devastating. So yeah, I think Texas at least has said, all right, Supreme Court, you're going to stir things up. We're going to stir things up. Now, unfortunately, or unfortunately, depending who you ask, Texas doesn't get the last word. The Supreme Court will. It really is one or two people will get to the last word here. Look at this side. Nothing from this side.
I have a question.
Please, yeah, JC, go ahead. My wonderful host. Thank you.
So whatever the Supreme Court's decision is after oral arguments today, what effect will that have on Lubbock as a city that has adopted a sanctuary city?
Well, thank you. I forgot the actual Lubbock. While I was invited here. Does Lubbock have any abortion clinics?
We do. We are the only city who has adopted an ordinance that has an active campaign.
Is it open or closed?
It's open, but they're not providing abortions.
So what are they doing? Just health, physicals and pap smears and things like that?
Yeah.
Well, look, if the court, sorry, this gets gross. I'm sorry, periods and pap smears. Yeah, I gave a warning. Look, we're all adults here. Okay, so to answer your question, JC, if the court upholds SB 8, then I think the Lubbock law remains valid in its entirety. There's really not much of a difference if the state enacts it versus the local government enacts. I know there's a pending case in federal court here that's sort of kind of just waiting to see what happens with the SB 8 one. But good question. Oh, yes, go ahead.
Do you think there's something weird about periods of action?
I've given this talk before, and I get uncomfortable giggles when it happens, so it's nothing weird. That's really natural. Yes.
If it's found that the Lubbock sanctuary city law is unconstitutional or whatever, would that make other types of sanctuary cities also unconstitutional?
Well, in what context would the law be declared unconstitutional? If the court's not standing, there's no way to adjudicate the issue. I think the only way to adjudicate the issue is if a doctor in Lubbock actually performed the abortion, they were sued for performing it, and then the court held that you can't enforce it. But JC told me that the clinic is not open, so the performance services, so there's no test case. I think the Solicitor General made this point, I think, quite well today. She said, or maybe it was the lawyer for the abortion clinics, he said we shouldn't require doctors to break the law in order to test the validity of an action, right? In other words, we shouldn't have to force someone to go ahead and perform this procedure knowing it's illegal and wait to get sued. And that raises the question, do you have a constitutional right to a pre-enforcement challenge? We keep circling back to this point, right? And if the answer is no, then sometimes the only way to test the law is to violate it. You all know what a test case is, right? A test case, you learn about this in your various classes. Historically, someone would deliberately violate the law knowing they would get sued or even thrown in jail even, right? A lot of the most famous cases involve people risking their own personal security and freedom in order to see if a law is valid. Another option, which is unlikely, is that Congress intervenes, and Congress says, if any state nullifies a constitutional right, the United States can come in and sue, right? They've done that for equal protection, right? If a state violates equal protection, the feds can go by statute and sue. But that hasn't happened here. But it's a good question. Other questions?
Okay, I think we're about out of time.
Are we over at 12:50?
Yeah, we're at 12:50. Anyway, everybody, please give our Professor Rosen a
so much.
I worked with one of your